Right, hello everybody, and you're very welcome to this Equity and Trusts FE1 Night Before Notes quick session. You'll see on the PDF uploaded that we start off these notes with a couple of pieces of gentle advice for the exams, some tips to look out for, some pieces of advice of things not to do on the exam paper. Particularly for those students who haven't studied law before, I'd really recommend having an overview of your exam technique and tips for answering the questions before you go into the exam, just to remind yourself of the approach to problem questions, to essay questions, and to the note questions as well. The purpose of today's session is to do an overview of what we think is going to be important for the exam by covering a couple of key topics. I of course don't set the exam, but there are some key areas that come up on pretty much every sitting which we'll look through today. The purpose is not to overload you with information or loads of predictions, but to focus on some core topics that'll help focus your preparation for the exam. And for that purpose, we are looking primarily at 4 topics from the Equity and Trusts course today. The first of those being charitable purpose trusts, the CPRE doctrine, and non-charitable purpose trusts, which you'll know yourself are very popular topics on the exam. They have come up in some form in at least once in the past 21 sittings. So at least one of these areas comes up in the past 21 sittings. So it's incredibly popular and an area that you really must look at to give yourself the opportunity to answer these questions on the exam. In terms of how it comes up on the exam, it's typically examined in the form of a problem question. The problem question could deal solely with charitable trusts, but it also can bring in elements of all 3. And in recent times, an essay question on the CPRE doctrine has been more popular with the examiner. But the structure of how you'll look at the topic is pretty similar whether you're looking at the problem question or whether you're looking at an essay style question. You can start things off from our historical perspective. Where does this concept of charitable purpose trusts come from? We have the Statute of Charitable Uses, CIT and PEMSL, and Ree Howley's estate. What's important at this point to note is CIT and PEMSL and the categories as set out by Lord Macnaghten. What happened in CIT and PEMSL is Lord Macnaghten looked at prior case law and the preamble of the Statute of Charitable Uses and distilled the idea of charitable purpose trusts into these 4 categories. They are trusts for the relief of poverty, trusts for the advancement of education, trusts for the advancement of religion, and trusts for other purposes beneficial to the community. And that remained the case until the Charities Act 2009, but still, broadly speaking, Section 3.1 of the Charities Act 2009 mirrors those categories as set out by Lord Macnaghten, even though they aren't exactly the same. For example, under the old law you had trusts for the relief of poverty, but the 2009 Act now includes trusts for the prevention or relief of poverty or economic hardship. But trusts for the advancement of religion are the same, and then we have trusts for trust for the advancement of education, and trusts for any other purpose to the benefit of the community. And these are captured in categories A to D in the current 2009 Act. I note here that the Charities Amendment Act 2024 was signed into law on the 10th of July this year. It is yet to be commenced, and the Act primarily makes changes to the regulation of Irish charities by the Charities Regulatory Authority, but there are some changes that we can note at this point. So Section 3D of the 2009 Act, which includes, as you see here, trusts for any other purpose of benefit to the community, is going to be replaced by a list of 14 activities, which now include different purposes such as the advancement of human rights, the protection of the natural environment, and includes a further list of any other purpose that is of benefit to the community, where that purpose is similar to any of those listed in paragraphs A to Q. So this 2024 Act brings a change to this element of the 2009 Act. What we also note here is Section 3.2 of the Charities Act 2009, which states that as well as coming in underneath one of the classifications of a charitable gift, it must be of the public benefit. And under the old law, the concept of public benefit varied between the different classifications of trust. However, with the view of the 2009 Act, that's no longer the case. And that comes into play when we look at the first item here, trust for the prevention or relief of poverty or economic hardship. We turn to the case of Re Coulthurst, which gives us our definition of what we mean by poverty. It doesn't have to be severe destitution, but just the means of going without. Prior to the 2009 Act, there was an understanding that the idea of a personal nexus or a public benefit requirement didn't apply to poverty in the same way it applied to other categories. To that end, we had cases where gifts were allowed to count as charitable, even where they were to poor relations in Re Scarisbrooke, poor employees, that's Dingle and Turner, or members of the same profession, we see that in Re Denison. And what you need to be clear on here is that the 2009 Act most likely abolishes that personal nexus and public benefit exemption. And you can give reference specifically to section 3.2 to section 3.8 of the 2009 Act to discuss and delineate why those exemptions are likely to be gone. Trusts for the advancement of education. This can certainly come up in the problem question on the exam. Usually you'll be faced with a recreational activity and you'll have to decide whether or not it can be linked to education for it to be deemed charitable. Be prepared to discuss artistic or musical gifts and particularly be focused on sporting activities. Here, a case like IRC in Macmullen is helpful because it gives us the high point of gifts that appear to be purely recreational being tied in with education. Here, the English Football Association managed to tie in gifts of a footballing nature because they were linked to schools. What's also interesting to note is the Canadian Supreme Court decision in Amateur Youth Soccer Association and Canada, because it's a recent persuasive authority which said that football in Canada is not charitable in and of itself. There has to be some real link to education, and that's what you'll have to look out for on the exam. In terms of trusts for the advancement of religion, in general the Irish approach to this is subjective, whereas the English approach is an objective one. In section 3.4 of the 2009 Act, we specifically deal with the advancement of religion, and it states that it shall be presumed, unless the contrary is proved, that a gift for the advancement of religion is of a public benefit. It's also worthwhile noting that the court will look at whether a gift is religious or not, and section 310 of the Charities Act goes to note that a gift for the advancement of religion is not a gift if it's made to or for the benefit of an organisation or a cult. What's also possible to come up in the exam is a problem question where a gift is made to a religious person and you have to decide whether or not that is a benefit for the advancement of religion or not. It's also good to note section 49 here of the Charities Act 1961, which in our jurisdiction acts as a saviour for mixed trusts. It means that if we have valid charitable purpose trusts, we can give effect to those parts, even if there are non-charitable parts of that same trust. We can give effect to the valid aspects, and that provision does not exist in England. Then turning to charitable purposes of benefit to the community, a non-exhaustive list is currently set out in section 311 of the 2009 Act, and this subsection is going to be deleted by the Charities Amendment Act 2024. This will now be captured, as we've already discussed, by the insertion of new paragraphs at section 3.1e to f. That's coming in with the Charities Amendment Act 2024, which expands the categories under which we deem are of benefit to the community and still retain that it's non-exhaustive and it can be charitable if linked to one of those other categories. However, what still is unchanged is the importance of our case law in this area, and in particular National Tourism Development Authority and Coughlin, the decision of Judge Charlton. Go through that in your manual. Your examiner really likes this case and acknowledges it in reports, and it's very important for the exam in terms of sports and also in terms of purposes of benefit to the community. Political trusts might also come up in a problem question. The general position is that political activity and all gifts to political parties will not attain charitable status. We do, however, have an exemption for bodies that promote a political objective which relates directly to the advancement of their charitable purpose. So, for example, if you're a charity for the prevention of poverty of children, and you wish to advocate on, let's say, a children's rights referendum because you're promoting a political objective which relates directly to the advancement of your charitable purpose, and that would be permissible. The next topic under this umbrella heading is the CPRE doctrine. And under this CPRE doctrine, where a charitable trust fails, a court may apply the gift in that trust to objects as near as possible to the original object. So that's what we have with CPRE here, as near as possible. The vital piece of information to always remember at this point is that the doctrine is only available where the original trust is for a valid charitable purpose. People always make that mistake on the exam, and the examiner always picks it up. We have to first look at whether the original trust is for a valid charitable purpose. Then following from that, the main distinction in the CPRE cases is where the trust becomes impossible due to initial impossibility, and cases where there is supervening impossibility. Pay particular attention to the case there of Reed Jordan, as that case has provided the fact pattern previously for problem questions in the exam. The CPRE doctrine certainly can come in mixed with the charitable purpose trusts in a problem question. If you are to see the CPRE essay on your exam paper, you need to focus on the last part of your manual on CPRE and on section 47 of the Charities Act, which has expanded the parameters of the CPRE doctrine. Finally, in this category, we turn to look at non-charitable purpose trusts. And as I mentioned, it's important to study all of these kind of three broad headings together. And so, along with the charitable purpose trusts, this is an exemption that for a trust to be valid, it must be for human objects. And the main categories we are looking at under non-charitable purpose trusts are trust for the erection or maintenance of monuments or graves, which we see in Re Endicott, and we'll also note there section 50 of the 1961 Act and the Law Reform Commission's recommendations on monuments and graves and that effect. And also the maintenance of particular animals as noted in Re Wedgwood, so not animals more generally, but particular animals. And so even where a valid non-charitable purpose trust falls under one of these exceptions, it's important to note that it must also, will first be for a purpose previously upheld by the courts. That's why we're looking at these particular categories. It must secondly have someone willing to execute it, for example the executor to the will, and the trust must be limited in perpetuity. We also take a quick note of the Charities Amendment Act 2024. We've mentioned it already. As I said, signed in on the 10th of July this year. It's yet to be commenced, but the bill has been enacted and we can see the changes it's going to make. Again, it's mainly about regulation, but we have this inclusion of new categories, including advancement of human rights and the protection of the natural environment in section 3D of, inserted into section 3D of the 2009 Act. So it expands things there and gives a further list of categories and retains an element of anything else that is of benefit to the community if it's similar to the purpose as listed in paragraphs A to Q. And so I'd encourage everyone to have a look at that. It also codifies certain duties of charity trustees, for example, to act in good faith, the best interests of the charitable organisation. We raise those because they can be important and good to mention in the context of a charity problem question, but it also helps our understanding of trusteeship and trustees' duties and where they're enumerated more generally. Alright, so the second big topic we're looking at in today's session is the topic of injunctions, another extremely important topic on the exam that comes up on pretty much every sitting in some form, and there's a couple of subtopics in the overall injunction area. We're first looking at interlocutory injunctions. This is our baseline. We need to know the American Sanamide and Ethicon principles, serious questions to be tried, balance of convenience, and adequacy of damages. Remember, we're looking at this at an interlocutory stage, so before the full hearing, preserving the status quo between the parties. This test is adopted in this jurisdiction in Campus Oil, and of course that's a very important case for us to know. And from there, we look towards the more recent and subsequent Irish decisions particularly Merck, Sharp and Dome, in terms of how injunctions in this jurisdiction have developed. Our baseline is interlocutory injunctions, but what's common on the exam is an essay question on interlocutory mandatory injunctions and the test which has to be applied for those. And we have steps on this one. We start from the campus oil approach, moving to the strong case approach, our most important case there being Mahalingam and the HSE, in terms of the mandatory nature of this interlocutory injunction. But again, it's building on it step by step from interlocutory to this mandatory interlocutory relief. What you also need to tie in is the fact that the court has more recently promoted the idea of flexibility in the injunctive remedy, and the fact that really, rather than focusing on prescriptive approaches, you need to look at where the least risk of injustice lies, taking everything into account, the balance of convenience, the adequacy of damages, the least risk of injustice, and that comes from the decision of Mr. Justice O'Donnell, as he then was, in Merck, Sharp and Dome. So again, that's very important to mention in this regard. Then we look at quietimus injunctions. These typically come up every 4 or 5 sittings as a problem question. It is something that we would perhaps be due to see on this paper. It's where a wrong or an injury is anticipated or threatened or has not yet occurred. The substantive test doesn't change. We still have the same legal principles carrying on from our interlocutory relief. What is different here is that we have a different evidential burden. And that is borne by the fact that the wrong has not yet occurred. You have a number of cases there which establish these points, the most important of which being SASBO, which was further applied in this jurisdiction in the Ryanair and Air Rianta case, which shows that you must show a substantial risk of danger in order for a court to be satisfied that you would be entitled to a quietimus type relief. I also note the case of JRM Sports Limited and the FAI, which outlines that damages would not be an adequate remedy in certain situations. Here it was for sporting, but this is also an important case where we're looking at damage to the environment, child welfare, whereas the issues of the wider community are at stake, where damages would not sufficiently compensate an apprehended wrong in that regard. Moreva Injunctions has been very popular on the exam in recent years. It's our freezing order, and what we have here is it's broken down into its kind of elements of how we think of and look at the Moreva type relief. We need full and frank disclosure, good arguable case, looking at requisite intent, which can be difficult to prove. We also have here where the proofs and guidelines can be found, the proofs for an Moreva injunction in third Chandris, and the guidelines for putting out Moreva type relief in the Rassiu Maritime case. We also have a very recent decision in the High Court by Miss Justice Roberts in Kieran Milling Unlimited Company, which I recommend you having a look at because it's a very succinct way of looking at how the courts will approach Moreva type relief. We can also look briefly there at worldwide Moreva orders, which might come up as an aspect of a problem question. Important there to look at is the Dodorian case, which lays down the guidelines for the granting of worldwide Moreva type relief. We also have here on the PDF the Anton Pillar orders. This would typically come up as a note question. I think, as mentioned in class, if you have the opportunity to answer a different note, I'd recommend doing that one. There's not as much to say in this part, but it still comes under our umbrella heading of injunctive relief and could come up as a note question on the exam. Turning now to trusteeship. Trusteeship comes up frequently on the exam. It didn't feature hugely in the last sitting, so it's certainly something I would take a focus on. It can be examined as either a problem question, an essay question, or a note. And really the topic can be broken down into a bite-sized mini-series of notes. For example, on the duty not to profit, which ties in with remuneration of trustees. And what's also important to remember when you're talking about trusteeship is what we know of our constructive trusts, particularly in relation to the cases about fiduciaries. And to that end, we refer to cases such as IDC and Cooley. Self-dealing and fair dealing could come up as a note question that's pretty straightforward. The duty to invest comes up. Note where a scenario where there's 2 investments are made, both of which are unauthorised. One does well and the other doesn't. Our cases to note there are Knott and Cotty, Dines and Scott, Bartlett and Barclays Bank. The rule in re Hastings-Bass can also come up as a note question, which deals with the duty to properly exercise discretion, and that case is affirmed in this jurisdiction more recently in Green and Cody. Trustees' powers are most likely to come up in a problem question tied in with the removal of trustees. So there isn't a huge amount in any one aspect of these, so it's important to look through and have an understanding of trustees' duties and trustees' powers, particularly when they come up in the context of problem questions, so you're prepared to apply them. The topic I also raise in this session is the topic of secret trusts, which most frequently comes up on the exam as a problem question. It will be a 20-mark question, and were due to come up thereabouts in this sitting. The key to answering a secret trusts question is to have an understanding of an ability to apply the rule in re stead. And for those reasons, we need to look at the distinction between trusteeship under a tenancy in common and a trusteeship under a joint tenancy. But where you're asked a question that relates to re stead, particularly a problem question, we can still go through secret trusts more generally, and it's important to have an understanding of where they're coming from. So we know that a secret trust is where from the face of the will it appears that our intended secret trustee will be taking the property beneficially under the will. There's no indication that anything else is going on. Our guidelines for this are set out by Lord Westbury in McCormick and Grogan. We have the intention to create a trust, communication of the intention to create a trust to the secret trustee during the lifetime of the donor, and acceptance by the secret trustee of that trust obligation. We also move on to look at intention and communication and issues with acceptance of the secret trust obligation. By contrast, half secret trusts are where we do have an indication that the donee is not taking beneficially under the will, but we don't have the full picture. In Blackwell and Blackwell in England, we have a requirement for the trust obligation in half secret trusts is stricter than that in fully secret trusts, where communication must take place before or at the time the will is made. In Reardon and Bannon in this jurisdiction, that's not the case, and the secret trust can be communicated prior to the testator's death, which is confirmed in Prendeville and Prendeville in this jurisdiction also. So it's important to go back through and have an understanding of that, and then also to look at the rule in re stead and how that arises in the problem questions. And I note that where, for example, a half secret trust is created, the intended trustees will usually hold as joint tenants. And this is where we have the rule in re stead triggered. So where there is a failure by the testator to communicate to some but not all trustees, then the failure to communicate to some is what we say triggers the rule in re stead. If the communication did occur and predated the making of the will, then all of the joint tenants will be bound. But if it occurred afterwards, then only those who received communication will be bound, so long as the other intended trustees knew nothing of the trust obligation, then they will take beneficially. So it's important to go back through with that and see how it applies to the problem questions. What we can note now is that you, of course, have some choice on the exam. The topics that we have looked at in this session are very frequent on the exam, and you certainly should spend time studying and preparing for those. After that, you do have the ability to make some choices and focus on other topics. I wouldn't ever recommend leaving out too much. It is a broad course, and it's important to have a holistic understanding of the topics as they can assist you across all answers. The content is vital, but what's also important is your exam technique, as I mentioned, and I really would advise in your final preparations for the exam to look at past papers in order to target your study to the exam paper. Luckily, we have frequently similar questions coming up on the Equity and Trusts paper that we can use to help our preparation. So I hope that this brief session has been helpful. I wish you all the very best of luck on the exam, and you can find more information, videos and notes on the Equity Trusts page on Moodle. So the very best of luck to everyone. Thank you.